to the defendant. 74. The defendant submitted that first, the statutory preconditions in the Act have not been met. Second, the court would not be satisfied to the necessary degree that the defendant poses an unacceptable risk of committing a serious terrorism offence, if not kept under supervision under the Act. It was also submitted that third, the court would not be satisfied that the matters alleged in the documentation would, if proved, justify making the ESO. There's several layers here in that the police have not proven that any terrorist organisation, terrorist act has taken place or exists. They have not proven that there's any risk of violence. And then thirdly, they haven't proven why someone should be watched by the police continuously. 75. It is significant that the offending for which the defendant was sentenced under the code was relatively low level, in that it was a simple offence of using a carriage service to menace, harass or offend, rather than the type of offending in Chapter 5C of the Code, urging violence against the Constitution or against groups or advocating terrorism. 76. Whilst the defendant's possession of an unregistered gel blaster was sufficient to qualify him as an eligible offender, the nature of the offences weighs strongly against the order being made. That says something about the legislation created by a parliament in relation to toy guns. 77. There were submissions made about whether the service requirements under the Act had been met and whether there had been disclosure as required by the Act. But these matters were in my view faintly pressed, and the application was defended on the basis of the material being properly before the court. 78. What was pressed, however, appropriately in my view, was the problematic bases of the psychologist's risk assessment report relied upon by the plaintiff, purporting to calculate the likelihood of the defendant committing a serious terrorism offence. This report of Miss Prince was heavily qualified, referring to itself as a, open quote, interim assessment, close quote, only, and concluding that any risk presented by the defendant required a narrative shift occurring before any such activity would proceed, and it would be activity in which his role would likely be limited to promotion, recruitment, and development of material. It was in this context that she assessed the defendant as presenting a, open quote, moderate to high risk, close quote, using the Violent Extremism Risk Assessment Tool, VERA. There was nothing in the report, however, that assessed the likelihood of the contextual change of or narrative shift actually ever occurring, and so her conclusions remain speculative. Pre-crime is the way I have described it. These speculations that are allowed on behalf of the police when they're applying in a court, but are not allowed on behalf of the defendant when defending himself against such spurious accusations. 70. The defendant disputed that he should be correctly considered a, open quote, convicted New South Wales terrorism activity offender, close quote, even under the extended definition set out in Section 10(1)(a) of the Act. 80. Section 2 of the Act sets out the matters the court may consider in determining whether the defendant is in fact a convicted New South Wales terrorism activity offender. 81. First, the sentencing magistrate specifically declined to sentence the defendant on the basis that he had an allegiance to a particular group. Second, evidence adduced on sentence did not properly lead to a conclusion that he was either making a, open quote, call to arms, close quote, to his associates to hang police or engage in any act of violence. In fact, there was a number of statements that show an intention to act peacefully and that he expected others to act peacefully. Third, there is no relevant terrorism intelligence. The material in the affidavit of Detective Senior Constable Reason is not a report relating to terrorism or a terrorist organisation. It is full of speculation and opinion without real foundation as to what other unidentified people, open quote, might do, close quote. Emphasis was also placed on the concluding paragraph of Detective Senior Constable Reason's affidavit, that it should be read as a, open quote, picture of a group that has effectively dissipated, with members being disillusioned and having moved on to different groups, full stop. 82. Fourth, there was nothing in the prior convictions relevant to terrorism or of sufficient seriousness to give any concern about the defendant having potential to commit serious terrorism offence in the future. There's no evidence whatsoever to prove or justify that any terrorism offence was going to take place in the now, Matthew Reason, or in the past.